Young Arif and my ladies, may I begin? Much
Yes.
obliged. Good morning, Young Arif and my ladies. My name is Nurul Azini Zafira binti Sabarudin, appearing as Senior Counsel on behalf of the appellant, Mrs. Amrita. And together with me today is my co-counsel, Mrs. Nur Afrina Safia binti Muhammad Azri. On the side of the opposite bench is my learned counsel, Mrs. Ainur Kristina binti Mat Khairi, and her co-counsel, Nur Fatin Nadia binti Johari. I will be allocating 18 minutes for my submission, and my co-counsel will be allocating 17 minutes for her submission. 5 minutes will then be reserved for rebuttal and rebuttal session. I will be submitting the first issue, and my co-counsel will be submitting the second issue. Before I proceed, do this honorable court need assistance on the facts of the case?
Sure.
Much obliged. Amrita, the appellant, suffers from multiple sclerosis. In October 2017, when she first experienced the numbness in her left limbs and right legs, she made an appointment with Dr. Kevin at SMX Medical Center and was diagnosed with secondary progressive MS. However, Dr. Kevin neglected the action to confirm his diagnosis with any other specialist, and he also did not arrange any follow-up. Later, her disease had developed into primary progressive MS, and consequently, on 25 August 2019, Amrita was admitted to XYZ Hospital with a serious bladder and bowel dysfunctions, which are the symptoms of the disease growing into bladder cancer. In October 2018, she suffered a relapse due to a developing tumor in her regional lymph nodes and later was told that she is incurable. Even worse, Amrita had to give up her work and lived in pain and anguish as the cancer left her with a severe and worse gastrointestinal obstruction and bleeding problem. If only Dr. Kevin did not delay in his referral, Amrita would have had 40% of remission amounting to surviving 10 more years, as further provided by a pathologist from Seremban Specialist Center. Young Arif and my ladies, therefore, I shall now proceed with my submission. There are two issues to be submitted before this honorable court. First, Dr. Kevin has committed medical negligence by breaching his duty of care towards the appellant. And second, SMX Medical Center is vicariously liable for the medical negligence committed by the appellant, by Dr. Kevin. My apology. Young Arif and my ladies, if there is no further inquiry, may I proceed with the first issue? Much obliged. Young Arif and my ladies, for the first issue, we submit that Dr. Kevin has committed medical negligence by breaching his duty of care towards the appellant based on three grounds, which are: first, the existence of doctor and patient relationship between Amrita and Dr. Kevin. Second, Dr. Kevin is liable for the delay in referring his diagnosis to any other medical specialist. And third, Dr. Kevin has failed to advise Amrita on the risk of bladder cancer and brain damage. Young Arif and my ladies, to begin our submission on the first issue, I would like to bring this honorable court attention to the relevant cases that provide the existence of doctor and patient relationship constitutes a duty of care for a doctor towards his patient. First, the case of Fu Fiona and Dr. Su Fu Moon and another states that if a doctor and patient relationship exists, then the doctor owes his patient a duty of care, which is to diagnose, to treat, and to advise his patient. Further, in R and Batman, the relationship between a doctor and patient first first existed when the patient consulted with the doctor and submitted to his treatment accordingly. Hence, Young Arif and my ladies, we submitted that in this instance case, Amrita made an appointment with Dr. Kevin. She also underwent the treatment instructed by Dr. Kevin at SMX Medical Center. As Amrita consulted with Dr. Kevin and submitted to his treatment accordingly, then this is when their doctor and patient relationship exists. And that is why Dr. Kevin owes Amrita a duty of care. Young Arif and my ladies, for the second ground of this issue, we submit that Dr. Kevin is liable for the delay of referring his diagnosis to any other medical specialist. The illustration of the delayed referral can be inferred from the case of Ahmad Takif Amzar bin Ahmad Huzairi and Kuala Terengganu Specialist Hospital, where in this case, the plaintiff parent came to the hospital where the second defendant attended to the plaintiff. At first, the plaintiff had a fever and swelling in his neck, but ended up suffering permanent disability. The court held that the plaintiff should have been referred to the specialist at earliest stage when the first symptoms showed up, which is the swelling in the neck and the high fever. For better illustration, in the case of Gordon and Wilson, the court accepted that the defendant should have referred the plaintiff to the specialist at earlier stage when the plaintiff first complained about her symptoms. As such, Young Arif and my ladies, we submit that in applying to the present case, Amrita, who suffers from multiple sclerosis, put high hopes and trust to Dr. Kevin as her doctor by relying to his proposed treatment and consultation after she made an appointment with Dr. Kevin.
Counsel, if I may stop you there. In the facts, your client has been told that your client is suffering secondary progressive MS. So upon being told that, your client is having secondary progressive MS, your client should have, went to any specialist for another secondary opinion or second opinion. Why didn't your client go and see other doctors, but perhaps, just wait for Dr. Kevin to provide any medications or any treatment to your own client?
Thank you, Young Arif, for addressing your concern. Dr. Kevin should have referred Amrita to another medical specialist specialized in multiple sclerosis because he only a regular doctor as provided in paragraph 2, line 7 in the mood problem.
But is it not that your client is a 45 years old lady, so she should have known that, upon having this secondary progressive MS, that your client should have been worried about the disease. So your client should have seen other doctors. Why didn't go and see other doctors?
Thank you, Young Arif, for pointing that out. In this instance case, Amrita is only a layman which she has no medical background, which why she relied on Dr. Kevin as her doctor to uh, to make a referral on behalf of Amrita, as Dr. Kevin has a duty towards Amrita to has a duty of care towards Amrita due to their doctor and patient relationship when Amrita first consulted with Dr. Kevin at SMX Medical Center.
But is it not that your client have been seeing this Dr. Kevin for quite some time and her numbness is still going on? So why still keeping going to see Dr. Kevin and not going to see other doctors?
Thank you, Young Arif, for addressing your concern. May I be given a moment?
Yes, yes, please.
Much obliged. Yang Arif, according to the book of Cons Current Therapy, which written by a specialist in multiple sclerosis, which is a neurologist, uh, B. Mark Kagan, um, in page, my apology, in page 684, the neurologist stated that multiple sclerosis patient clinical assessment range from 6 to 18 months. That is why Dr. Kevin has to observe Amrita in that range of time for the clinical assessment purpose.
6 to 18 months. For how long that your client have been seeing Dr. Kevin?
Thank you, Yang Arif, for pointing that out. Amrita uh, had seeing Dr. Kevin for only 5 months.
Then according to your bloody book, then the patient shouldn't go to see any other specialist then. They should rely on ordinary doctor.
Thank you, Yang Arif, for pointing that out. The her doctor should be the one who responsible to refer her for to another specialist, as stated in the case of Gordon and Wilson, where the patient consulted the doctor on several occasions, where she complained the symptoms of deafness, and then she complained the symptoms of difficulties in drinking and eating, and the difficulties on balancing herself. But only after several occasions, the doctor referred her to the specialist, where the specialist actually diagnosed her with a tumor, a benign tumor, and then the specialist conduct a surgery and removing the tumor, and the court held that the defendant should refer Amrita. My apologies. The defendant should refer the plaintiff in that case at earlier stage when the symptoms first showed up.
Counsel, according to your neurologist book just now, that 6 to 18 months that the patient gonna develop this cancer. But according to you, that the patient have been seeing Dr. Kevin for 5 months now. So after that 5 months, that your client never ever go and see Dr. Kevin anymore. So are you suggesting that your client contributed to her own cancer, not Dr. Kevin? Should your client go and see Dr. Kevin after 5 months of treatment, then your client should have been referred to the specialist.
Thank you, Yang Arif, for pointing that out. This brings me to my last submission, which is the failure to advise. Dr. Kevin failed to advise Amrita regarding the seriousness of her condition, which we submit that if Dr. Kevin had explained the risk or the seriousness of Amrita condition, then Amrita will have known the condition or the seriousness of her disease, and then for her to be submitting to Dr. Kevin's
But
appointment.
the fact says that Dr. Kevin has diagnosed Mrs. Amrita for secondary progressive MS, so that is not yet developed to become a cancer. So that is why Dr. Kevin haven't referred your client to any specialist. But perhaps that he would like to wait until 6 or more months after the treatment, because according to your book just now, that 6 to 18 months the cancer would have developed. So while waiting for your client to be referred after the 5 or 6 months of the treatment, then your client will be referred to the specialist, but yet your client didn't turn up.
Thank you, my lord, for addressing your concern. Indeed, my lord. However, Amrita's numbness or symptoms had shown up 9 months prior to she consulted with Dr. Kevin. Thus, Dr. Kevin should add up the the range of time which her symptoms showed up, and um, the multiple sclerosis disease also a rare disease for Asian descent. So Dr. Kevin, when he diagnosed Amrita with secondary progressive MS, he should foresee the risk involving with this disease, because this disease itself is rare. Then when Amrita came to him with multiple sclerosis, and then he diagnosed Amrita with the secondary progressive MS, he also should foresee the risk involving with the disease.
Do you think that a 45 years old lady, have numbness is very common? So that is why Dr. Kevin doesn't refer your client to any specialist because of being rare. I mean, the cancer to be rare, to be caught by any Asian female ladies or female Asian descent.
Thank you, Yang Arif, for addressing your concern. However, the mood problem, paragraph 1 states that Amrita already suffers from multiple sclerosis. And then when she consulted with Dr. Kevin, then Dr. Kevin diagnosed her with secondary progressive MS, which is the second stage of the multiple sclerosis.
At present.
Much obliged. Young Arif and my ladies, I would like to draw this honorable court attention to section 18, subsection 1, paragraph A of the Private Hospital and Other Private Healthcare Facilities Act 2006 that highlighted a patient's right to be provided with the information related to the nature of her or his medical condition and any proposed treatment. With that, Young Arif and my ladies, we submit that in the present case, Dr. Kevin clearly owed Amrita a duty of care to advise Amrita regarding the seriousness of her condition. He also responsible to propose any treatment or prescribe any medication to prevent her disease from worsen, as Amrita is capable to understand such advice. And furthermore, Dr. Kevin should have had advised Amrita regarding the risk and complication involving with her disease. However, Dr. Kevin failed to warn her regarding the neurological side effects, the bladder cancer, and brain damage, which amounting to the breach of duty of care.
Counsel, do you think that after the 5 months of treatment in paragraph 3 of the facts, that your client did not attend any medical treatment thereafter? So do you think that should your client attend any medical treatment during that time, do you think that Dr. Kevin would have advised her to see any specialist?
Thank you, Yang Arif, for addressing your concern. Yes, Yang Arif, Dr. Kevin should have referred Amrita to another specialist because in the mood problem, paragraph 2 and 7 stated that he is only a general doctor, which is he does not have any specialization in multiple sclerosis, and that is why should refer Amrita to the specialist specialized in that field.
I'm asking after during the time that your client did not attend any treatment. If your client did go and see Dr. Kevin after that or during this not turning up a treatment, do you think that Dr. Kevin should have advised your client to see the specialist or refer your client to the specialist? But because your client didn't turn up, then there is no referral to any specialist then.
Thank you, Arif, for pointing that out. Before that, may I be given an extension of time?
30 seconds.
Much obliged. The Dr. Kevin should refer Amrita, even though the clinical assessment take to 6 or to 18 months for the purpose of observation, uh, but Dr. Kevin still not have the expertise in that field. Hence, we submit that he should make a referral to another specialist specialized in that field to prescribe an accurate medication or treatment to prevent the disease from getting worse. Much
Can I just
obliged.
ask just one
Yes, my lady.
Giving you an analogy, if you go to hospital, then you're not satisfied, you still go to hospital A rather than. Is it clear? Is the internet? The line cut off? Is it okay? Oh, I'm sorry. No, then never mind. Just proceed.
Much obliged, my
So
lady.
sorry. Okay.
As such, Young Arif and my ladies, we submit that Dr. Kevin has committed medical negligence by breaching his duty of care towards the appellant because he delayed the referral of his diagnosis for obtaining further confirmation from the specialist and later failed to advise Amrita accordingly. Young Arif and my ladies, having finished with the first issue, does this honorable court need any further clarification before my co-counsel continue to submit on the next issue?
We will reserve the court's questions to your learned counsel. Thank you.
Much obliged. If there is no further assistance favored by this court, that shall conclude my submission on the first issue. Thank you, Young Arif and my lady, for your time and indulgence.
Thank you.
Yeah, Arif and my ladies, may I begin? Much obliged. Good morning, Young Arif and my ladies. May it please this honorable court, my name is Nur Afrina Safia, appearing as the junior counsel on behalf of the appellant. Young Arif and my ladies, having finished with the first issue submitted by my co-counsel, I will now move on to the second issue, which is SMX Medical Center is vicariously liable for the Medical Negligence Act committed by Dr. Kevin. I will divide my issue to two grounds, which first, there is a special relationship between Dr. Kevin and SMX Medical Center, and second, the medical negligence committed by Dr. Kevin was done in the course of employment. Young Arif and my ladies, if there is no further question needed by the bench, may I proceed with my submission? Much obliged. Young Arif and my lady, on the first ground, we submit that there is a special relationship between Dr. Kevin and SMX Medical Center. I would like to bring this honorable court's attention to the relevant case that provide the element of vicarious liability, which is the case of Tan Eng Siu and another, and Dr. Jagjit Singh Sindhu and another. In this case, vicarious liability means when the employer is liable for the tortfeasor's wrongdoing or negligent. Three requirements must be satisfied. First, there must be a wrongful act or negligence. Second, there must be existence of relationship that is recognized by law between the person alleged to be vicariously liable and its workman. And third, the tort is committed within the course of employment. Hence, Young Arif and my ladies, we submit that SMX Medical Center is vicariously liable. Young Arif and my ladies, by referring to the mood problem, paragraph 2, line 4, line 5, my apology, it states that Dr. Kevin is an independent medical consultant. According to the memorial for the appellant, page 6, paragraph 25, in distinguishing between employees and independent contractor, the Ning Lord Judge in Cassidy and Ministry of Health opined that the liability of the hospital authorities does not depend solely on the existence of employment relationship. The judge in this case declined to consider the status of independent contractor among the surgeons and nurses involved in this case. Thus, this Court of Appeal found that the hospital to be vicariously liable for all medical staff's negligence involved in the operation. Hence, Yang
But
Arif,
counsel, if I may stop you there. No,
yes,
you're submitting on vicarious liability of the hospital because of the negligence, so-called negligence done by Dr. Kevin. But is it not that your client also have contributed to the negligence of Dr. Kevin? So it is not solely to be put on the shoulder of the hospital or Dr. Kevin.
Yang Arif, thank you for addressing your concern. However, Yang Arif, I beg to differ. Amrita did not contribute to her own negligence. Yang Arif, according to paragraph 3 of the mood problem, line 4, yes, Dr. Kevin having carried the diagnosis. However, Dr. Kevin did not refer Amrita to a specialist for confirmation of the diagnosis. Thus, we submit that the diagnosis conducted by Dr. Kevin towards Amrita that considered as secondary progressive MS is not yet confirmed. Hence, that's why Amrita did not refer to another specialist as Dr. Kevin did not confirm the diagnosis conducted.
But is it not that according to your senior counsel just now that the results of the disease would have known after 6 months? So Mrs. Amrita just went and see your client only for 5 months. How would your client know? I mean, how would Dr. Kevin know the results within 5 months' time? Because according to the neurologist, that the result would have known after 6 months.
Yes, Yang Arif, thank you for pointing that out. Yang Arif, according to paragraph 2 of the mood problem, saying that the numbness experienced by Amrita was first exist 9 months prior to Amrita her treatment to Dr. Kevin. And in this case, Amrita as a layman with no medical background would never know the impact of the primary multiple sclerosis itself, and it is the responsible of the my apology, am I audible?
Yes, yes, yes.
I will continue. And in this case, Dr. Kevin, as the medical consultant, should be responsible to advise Amrita on the impact of the multiple sclerosis itself. Whether or not it takes 6 months until 18 months, Dr. Kevin still, as a doctor, hold the responsibility to advise Amrita on the risk of the symptom itself.
But your client has been suffering the numbness for the past 9 months before she went to see Dr. Kevin. Why wait until 9 months and see the doctor?
Thank you, Yang Arif, for pointing that out. Yang Arif, it is reasonable for Amrita to wait until 9 months because as an old lady, it is normal to experience numbness without realizing that actually numbness is the symptom of multiple sclerosis. My apology, Yang Arif.
If you're having fever for 9 months, is it normal to you because of your age? And you don't go and see the doctor because, oh, I'm that old, so it's normal for me to suffer fever for 9 months. Is that what you're suggesting?
Yeah, Arif, thank you for pointing that out. However, having a fever for 9 months is unreasonable to delay to take a treatment. But numbness itself, even we as a young people, we sometimes experience numbness. And for old lady, numbness for 9 months is actually normal, and it is reasonable for Amrita to not taking the matter up with Dr. Kevin, since Amrita is only a layman with no medical background.
So if it is normal, then why go and see Dr. Kevin? Just stay at home because you're old lady and it's normal to suffer numbness.
Yes, yeah, Arif, thank you for pointing that out. However, after the 9 months of experiencing the numbness, we submit that Amrita take the matter up with Dr. Kevin to know what is actually the symptom of numbness itself. And in this case, Dr. Kevin failed to advise Amrita that her MS is actually developing in her body, but Dr. Kevin did not advise her on the risk of the disease itself. Although Dr. Kevin has carried out a diagnosis, but Dr. Kevin did not refer her to another specialist. In fact, Dr. Kevin did not even confirm the diagnosis with Amrita.
But is it not that by telling Amrita that she is suffering secondary progressive MS while waiting for the results to be confirmed that Dr. Kevin has, already acted within his own medical experience that, the client will be suffering, but while waiting for the results, then let us wait and see. Because Dr. Kevin cannot, tell the patient you know, before he confirm about the disease. Don't you think so?
Yes, and Arif, indeed. Before the diagnosis is confirmed, then Dr. Kevin cannot tell Amrita to take another action. However, according to the mood problem, paragraph 3, line 4, it is only after Dr. Kevin has conducted diagnosis towards Amrita and he did not refer her to a specialist. He even though did not confirm the diagnosis with another specialist. And only after that, after 5 months, Amrita did not take any matter up with Dr. Kevin. Hence, it is reasonable for Amrita to only wait for Dr. Kevin. However, it is not reasonable for Dr. Kevin to not tell Amrita about the risk of the disease itself.
So when your client didn't go and see Dr. Kevin for any treatment, then your client did not take any medication after that. So because of that, the disease have been escalated. Don't you think so?
Yes, indeed, Young Arif, but it is because Dr. Kevin did not advise anything. So Amrita, as a layman, so my apology, am I audible?
Good, you're good.
Yes, you are.
Much obliged. In this case, Dr. Kevin did not advise Amrita on the risk of the disease itself. Hence, that is why Amrita did not seek another treatment or medication just because he didn't know the risk of the disease itself.
So you're
Yeah.
saying that your client has no suspicions at all. I mean,
Yes.
she's totally relying on Dr. Kevin.
Thank you, my lady, for pointing that out. Indeed, my lady, yes, Amrita only rely on Dr. Kevin as her regular doctor, as stated on paragraph 2, the last line.
But this is the question that I want to ask. If you went to hospital A and you did not satisfy with the service, shouldn't you just go to other hospital instead of waiting for such a long time and then develop other disease? I mean, let's off the book, let's off the law. This is logical thinking. What would you say?
Thank you, my lady, for pointing that out. If the doctor in hospital A did not advise me of any risk of the disease itself, then I think I would be like Amrita, that I wouldn't go to another hospital just to seek another medical treatment. In fact, SMX Medical Center is already a non-government hospital facilities. Then it could be another burden for me to pay for another cost of in the non-governmental hospital. May I continue, my lady?
Yes.
Much obliged. I will continue. Young Arif and my ladies, we submit that whether the negligence act made by employee or independent contractor, it is still insufficient to consider only on the status of employment. Further discussion can be seen in the case of Chai Bengkok and Sabah Medical Center Sendirian Berhad and others. The High Court held that the hospital is vicariously liable for the medical negligence committed by Dr. Heng, which in that time was considered as independent contractor by utilizing the control test established in the case of Tan Eng Siu and another, and Dr. Jagjit Singh Sindhu and another. In the latter case, the role of control test is to determine the existence of special relationship between hospital and independent contractor that can cause the hospital to be vicariously liable, even though the negligence was made by its workmen, even there is no employment relationship. Yang Arif and my ladies, the application of special relationship is further illustrated in the case of Vincent Manikam, son of David and others, and Dr. Sri Hari Raja and another. The doctor in this case is an independent medical consultant surgeon. However, the court found that there was a control over the doctor by the hospital, and it constitutes special relationship. Thus, every medical negligence committed by this doctor will be liable to the hospital itself.
Counsel, I have a
Yang
question.
Arif and my ladies, by referring to the appellant to the memorial for the appellant, page
Counsel,
yes,
my
Yang
learned
Arif.
sister would like to ask a question.
Yep, I have a question. Can you hear me?
Yes, yes.
Yes, okay. Now, Rafi, can you
Yes,
hear
yes,
me?
my lady.
So your first point is actually on special relationship. You've talked about the
Yes,
case
my
of Chai Ben Hock and Vincent Manikam to say that apart from employment, you also have to satisfy the control test. Now, my question here is, you've mentioned all this, but you've not applied it in this case. So what have you proven, what has the client proven against the hospital here to show that the hospital has a special relationship with the doctor? Because based on whatever information that we have now, he is an independent contractor and not employed by the hospital. So I want you to apply. How does it apply in this case? You can't just tell me that, there's this control test, but without showing further evidence on this.
Thank you, my lady, for pointing that out, my lady. In the present case, yes, Dr. Kevin is not an employee of SMX Medical Center in the sense that he is only an independent medical consultant. But the truth is, Dr. Kevin was for all intents and purposes and at all material times representing SMX Medical Center in treating the hospital's own patient. The hospital, in fact, did not own by Dr. Kevin, and Dr. Kevin did not conduct the treatment without any direction by the hospital. The patient itself went to seek treatment by SMX Medical Center and not by Dr. Kevin in particular. Hence, that's why the control test is established here when Dr. Kevin himself was directed by the hospital to treat Amrita as the hospital's patient.
Are you sure that's the case, or was it Amrita's choice to see Dr. Kevin? Was there a direction by the hospital for Dr. Kevin to treat Amrita?
Yes, thank you, my lady, for pointing that out. My lady, control and direction here does not mean that the employer must observe or give direction to every single act of the staff. However, stated in the case of various claimants and Catholic Child Welfare Society, The court stated that it is not whether the employer could direct everything that the staff has to do, but whether the workman was under the management of the employer. My lady, according to the moot clarification answer, paragraph 2, number 4, it stated that Dr. Kevin is working under SMX Medical Center. Hence, we submit that Dr. Kevin is still under management of the hospital, although he is only an independent medical consultant. My lady, have I enlightened your question?
It's okay, you may proceed to your next point.
Much obliged, my lady. Young Arif and my ladies, by referring to the appellant memorial page, paragraph 32, we would like to draw this honorable court's attention to the relevant provision, which is section 11, subsection 4 of Private Healthcare Facilities and Services Regulations 2006, which states that all registered practitioners who practice at private healthcare facilities shall be considered as part of the hospital. Young Arif and my lady, we submit that in the present case, the consultation and treatment committed by Dr. Kevin was part of the hospital's business activity. To add, the manner which he is obliged to practice as a medical consultant was also within the hospital authority. As such, it can be established that Dr. Kevin is a part of the hospital or hospital's organization since he is a medical practitioner and was employed by the hospital. Young Arif and my ladies, if there is no further question, may I proceed with my second ground under this issue? Much obliged. Young Arif and my ladies, as for the second ground under this issue, we submit that the medical negligence committed by Dr. Kevin was done in the course of employment. The judge in the case of Staten and National Coal Board, the Court of Appeal in this case held that the employer is vicariously liable for the negligence act committed by the employee in this case, and the employee, the workman in this case committed her negligence by collecting his wages from a part of board's premises after work, and my apology. Hence, the act of collecting wages and the premise involved in the negligence is considered as within the course of employment by the judge in this case. As such, young Arif and my ladies, we submit that in applying to the present case, every negligence act committed by Dr. Kevin, such as failure to advise the appellant and his delay in referral, were both done at the premise of SMX Medical Center. Thus, it is clear that the negligence was done in the course of employment. In addition,
counsel, if I may,
yes,
if the patient didn't come and see the doctor, so how could the doctor can give or could give any advice or any medical referral to any other specialist? So because of the non-existence of this situation, how could you say that the negligence have been done in the course of employment? Because there is no employment because the patient has never turned out to be referred or to be consulted with.
Young Arif, thank you for pointing that out. Young Arif, I would like to restate that according to the paragraph 3 of the mood problem line 4, which states that Dr. Kevin did not refer her to any specialist, and only after that, after 5 months of consulting with Dr. Kevin, Amrita did not attend any follow-up. Hence, we submit that within the 5 months, Dr. Kevin first, he failed to advise Amrita of the risk of the symptom itself. And second, Dr. Kevin failed to refer the diagnosis to another specialist to confirm the disease itself. Hence, that is why Amrita did not make any follow-up to the hospital, because he did not realize of this risk of the symptom itself.
Well, what is the position of Dr. Kevin again? What kind of consultant he is?
Dr. Kevin is, the position of Dr. Kevin is only an independent medical consultant, and he is a regular doctor for Amrita. Hence, we
Can you become a consultant if you are only a regular doctor?
Yang Arif, thank you for pointing that out. Yang Arif, we submit that regular doctor here means that he is a specialist that specialize in multiple sclerosis and treat Amrita as the regular doctor, even though he is the specialist. And in this case, if the specialist itself failed to advise Amrita, then it is all responsible and all the fault of the specialist itself to not advise Amrita of the risk of the disease itself. Yang Arif, have I enlightened your concern?
Yes, proceed.
Much obliged. I will continue. In addition, Dr. Kevin's act as a medical consultant and all the facilities utilized were all taken place and supervised by the SMX Medical Center, which caused it to be vicariously liable. Yang Arif and my ladies, may I be given an extension of time?
Yes.
Much obliged. Therefore, the counsels for the appellant respectfully request this honorable court to declare and adjudge that, first, there is a doctor and patient relationship between Dr. Kevin and Amrita. Second, Dr. Kevin is liable for the delay of referring her diagnosis to the specialist. Third, Dr. Kevin has breached his duty of care by failing to advise Amrita on the risk of bladder cancer and brain damage. Fifth, there is a special relationship between Dr. Kevin and SMX Medical Center. Sixth, the medical negligence committed by Dr. Kevin was done in the course of employment. And lastly, SMX Medical Center is vicariously liable for the negligence committed by Dr. Kevin. Young Arif and my ladies, having finished with the second issue, does this honorable court need any further clarification? Much obliged. If there is no further assistance favored by this honorable court, that shall conclude my submission on the remaining issue. Thank you, Young Arif and my ladies, for your time and indulgence.
May I begin, my lord, my ladies?
Yes.
Much obliged. Good morning, my lord and my ladies. May it please this honorable court. My name is Ainukistina binti Makhoiri, appearing as the senior counsel on the behalf of the respondent. And together with me, my learned co-counsel, Ms. Nurfati Nadia binti Johari. My lord, my ladies, I will be submitting on the first issue for 18 minutes, while my learned co-counsel will be submitting on the second issue for another 18 minutes, and we will reserve 4 minutes for rebuttal. Before I begin with my submission, do my lord and my ladies appreciate briefly summary facts of the case?
Yes,
Much
proceed.
obliged. My lord and my ladies, today in this honorable court, there are two issues of tortious liability need to be determined. The first issue is whether the trial judge was right in law in finding the respondent is not liable of medical negligence. And the second issue is whether the delay of action made by the appellant amounting to contributory negligence, therefore, maximum res ipsa loquitur applies. With regards to the first issue, we argue that the trial judge was right in law in finding the respondents not liable of a medical negligence, since there was no sufficient causation between failure to advise and the damage suffered by the appellant, which was proven through factual causation and legal causation. To argue these two, I'll divide my submission into two parts. First, I will argue the respondent's conduct was not, in fact, caused the damage suffered by the appellant. Secondly, I will argue that the appellant's damage was too remote and is not recoverable in negligence. My lord and my ladies, may I begin my submissions proper? Much obliged.
Yes, proceed.
Much obliged. My lord and my ladies, as mentioned before, the first sub-argument for issue 1 is the respondent's conduct was not in fact caused the damage suffered by the appellant. On the first task, under the first sub-argument, we submit that the damage suffered by the appellant would have occurred even without the respondent's negligence. For the but-for test of causation, according to the case of Dr. K.S. Sivanathan and the government of Malaysia in another, the plaintiff would be unable to prove. Am I audible? My apology. Am I audible to the court? All right. For the but-for test of causation, according to the case of Dr. K.S. Sivanathan and the government of Malaysia in another, the plaintiff would be unable to prove that the defendant's negligence caused his damage unless he can show on a balance of probabilities that proper treatment will be resulted in his improvement or stop the deterioration. Thus, referring to the same case, which is the case of Dr. K.S. Sivanathan, if the chance that proper treatment would have resulted in the desired outcome was less than 50%, the plaintiff had failed to prove that the harm would not have occurred in either case. Moreover, my lord and my ladies, the High Court in argument at Dr. Safikanan, anak lelaki Arunasalam in others, stated that the defendant's action was not a but-for reason if the harm would have happened anyway. Furthermore, in the case of Barnett and Chelsea, the plaintiff had failed to show on the balance of probabilities that the defendant's negligence resulted in the deceased's death. Moreover, the deceased may have died even if all precautions had been taken. In addition, the Court of Appeal in Hassan bin Datullah and Kerajaan Malaysia held that the appellant's paralysis, which resulted from his injury, was not due to the defendant's negligence in performing both operations. Thus, the defendant's negligence was not a but-for reason of the appellant's paralysis. My lord and my ladies, in the case at hand, the failure by our client, Dr. Kevin, to advise on the risk of bladder cancer and brain damage did not cause the damage suffered by the appellant, as the several symptoms of multiple sclerosis growing into the bladder cancer was only detected when she was admitted to XYZ Hospital in August 2019, as can be referred to the mode problem, paragraph 5, line 5. Moreover, my lord and my ladies, even if our client had advised the appellant on the risk, it would not have prevented the damage from occurring, as if I may bring the attention of the court to the mode problem, paragraph 7, line 4. According to the expert witness, with no delay in referral, the appellant would have had remission chance of approximately 40%. Hence, according to the case of Dr. K.S. Sivanathan, probability proper treatment by our client would have resulted in the desired outcome was less than 50%.
But counsel, though the
Yes,
chance of remission is only 40%, but your client has denied this 40% of chance to be given to the patient.
Thank you for addressing your concern, my lord. In addressing the court's concern, we submit that our client is not negligent, as the probability that proper treatment by our client would have resulted in the desired outcome was less than 50%, which is lower than the balance of the probability, whereby it is lower than the probability that the respondent's conduct caused the damage suffered by the appellant.
But is it not that 40% is still a chance? Counsel, is it not that though it is less than 50%, and according to the facts, it is only 40%, don't you think that there's still probabilities that the patient might have been cured or should have lived longer? but your client denied the right to live longer of this 40% and 10 years of extra living years of the patient.
Much obliged for addressing the court's concern. In assisting the court's concern, we submit that our client acted based on available medical evidence as when the appellant first sought medical treatment with our client, as can be referred to the mood problem paragraph 2. Our client had diagnosed the appellant as having secondary progressive multiple sclerosis, and also our client had setting up the appointments and consultation with her. Therefore, our client had fulfilled his duty of care as a doctor at that particular time. Am I addressing the court's concern, my lord?
But even if the client didn't turn up for any treatment after 5 months, but your client should have known that because of no treatment received by the patient, then the disease would have, getting worsened, So why didn't your client give the patient a call and ask her to come and see him so that treatments could have been given to the patient so that the patient would have lived longer? And that 40% of chance can still be given to the patient. But there is no efforts have been made by your client to the patient. I mean, to call and ask the patient to come and see him.
Thank you for addressing the court's concern. My lord, as the appellant first sought the medical treatment with our client, she asked about the numbness. She asked about the numbness that she suffered 9 months prior, and she sought the medical treatment with our client. As the numbness as the numbness presented by the appellant at that particular time can be treated. Therefore, Kevin had fulfilled his duty of care by diagnose her and consult her, and also setting up the appointments. Am I addressing the court's concern?
We just proceed.
Much obliged. My lord and my ladies, on the second test under the first sub-argument, we submit that the act of the respondent did not materially contribute to the damage as there were multiple causes. Pursuant to the case of Bonington Castings Limited and Ward Law, multiple causes refer to several causes not necessarily operating at the same time, and when they are each contributes to the final damage. The House of Lords in Wiltshire and Essex Area Health Authority held that the combination of the defendant's negligence and the plaintiff injury did not give any rise to a presumption that the defendant materially contributed to the injury where it could be attributed to a variety of potential causes. Furthermore, my lord and my ladies, in Hudson and East Berkshire Area Health Authority, the defendant was held not negligent because it was the accident itself that materially contributed to the plaintiff disease, not the defendant's delayed treatment.
So are you
Moreover,
suggesting,
the high...
counsel?
Yes, lady.
Sorry to interrupt you.
Okay.
So these multiple causes contributed does not negate that your client has also contributed to the negligence. Am I right?
For addressing the court's concern, in assisting this court, we submit that the appellant contributed to her own damage that will be submitted by my learned co-counsel after this. Am I addressing this court's concern?
My question was, you mentioned that there were multiple causes that contributed to the suffering of Mrs. Amrita, not solely upon your client's shoulder. Though there are multiple reasons for these sufferings, but it does not negate that your client also contributed to the negligence or to the sufferings of the patient.
Thank you for addressing the court's concern, my lord. In addressing the court's concern, in the case at hand, may I refer the court to the mood problem paragraph 2, line 2 to 4. The one of the causes of the damage suffered by the appellant was her condition, as when she first sought medical treatment with our client in October 2017, although the numbness was first manifested at 9 months before. And furthermore, according to the mood problem paragraph, the appellant also continuously delaying her medical treatment even after she has been diagnosed with secondary progressive multiple sclerosis, as she stopped attending any medical treatment after 5 months consult with our client. Besides, my lord and my ladies, if I may bring the attention of the court to the mood problem paragraph 5, line 2 to 4, it was the illness itself that caused the damage suffered by the appellant, as the several symptoms of the disease growing into bladder cancer were only found out when she was admitted with serious bladder and bowel function at XYZ hospital. Am I addressing the question?
Counsel, okay, maybe I'll ask something direct here. So
Yes,
you
maybe.
are arguing on causation. So can I ask you, there are two things here. It's one, either you're saying there was a breach of duty, but there's no causation, or there is no breach of duty on part of your client, and there is no causation. So which position are you taking? Are you saying that there is no wrongdoing by your client at all, but there is some wrongdoing by your client, but it is also contributed by the patient?
Thank you, my lady, for pointing that out. In assisting the court's question, we submitted that our client did not breach his duty of care as the independent medical consultant. Yes, this because our client had, as an independent medical consultant, had exercised proper treatment to the appellant, as he has carried out his duty based on the medical available medical evidence at that particular time when the appellant asked about the numbness. And thus, when the appellant asked about the numbness, our client had diagnosed the appellant as having secondary progressive multiple sclerosis, having a consultation with her, and also setting up medical appointments with her. This is in accordance with the Part 2 of the Code of Professional Conduct 2019 provided by Malaysian medical consultant, whereby the medical consultant have to provide the good standard of medical care, which are the diagnosis, the treating, and the consultation.
Counsel, sorry, are you saying that
Yes, my
hello?
lady.
Yeah, okay. Are you saying that is your client, what is your client doing is what other consultant would do? Is that the reasonable, other
Indeed,
reasonable
my
consultant
lady.
would do? Okay, thank you.
Indeed, my lady. My lord and my ladies, if there is no question, may I proceed with the second ground? Much obliged.
Counsel, is it a yes or no answer to the
Yes.
question just now?
Yes.
It's a yes, yeah?
Yes.
Yes.
If it is a
It is.
yes, if it is, yeah, Counsel, if it is a yes, then In para 7, there is another specialist, Professor Dr. Azran, said that should the patient, or I mean, should your client advise or refer the patient to any other specialist, then the patient would have been safe, or receive further treatment. So in this sense that the same reasonable specialist would have treated her differently in that sense.
Thank you for pointing it out, my lord. In assisting the court's concern, I refer to the mood problem, paragraph 6, line 4 to 6. It is stated that the appellant suffered severe side effects from the original treatment, particularly the high-dose treatment in August 2019. And also the wording in the mood problem paragraph 7 by the Professor Dr. Azran, he said that the wording of such as those. This means that there are other causes that resulted in the damage suffered by the appellant, which is the high-dose treatment that whereby, may I refer the court attention to the mood problem paragraph 5. It is stated that appellant subjected to one dose of intravesical chemotherapy for every 24 hours, involving removal of cancerous tissue and therapy for treating early stage bladder cancer. Am I addressing the court's concern?
No, I was asking that if the same treatment would have been given by any other specialist, then why did Professor Dr. Azman said otherwise?
Thank you for pointing it out, my lord. However, it is stated in fact in the book problem whereby the appellant suffered the severe side effects from the treatment, particularly the high-dose treatment in August 2019. Therefore, we submitted that the causes that it is one of the main causes that resulted in the damage suffered by the appellant.
So you agree that one of the
court's concern?
So you agree that one of the causes was contributed by your client for not referring the patient to any specialist after your client has known or came to the knowledge that the patient is suffering secondary progressive MS. So your client knew that this secondary progressive MS would have developed into a cancer, but yet he did not refer the patient to the specialist.
Thank you for addressing your concern, my lord. Indeed, there is delay. However, the delay is reasonable as according to the case of Abdul Ghaffur bin Muhammad Ibrahim and Pengarah Hospital, Kepala Batas and another. The High Court held that the doctor were reasonable of a competent or skilled medical consultant, whereby the defendants, the doctor's decision to admit and observe the victim was a reasonable course of action before they make another referral. Such acts, according to the court, should not be viewed as a breach of a duty of care or negligence as claimed by the plaintiff. Therefore, to relate to the case at hand, we indeed submit that the delay on our client's part to make referral is reasonable because as the appellant suffered the noise at that particular time, it still can be treated. Am I addressing the court's concern?
But expert evidence saying otherwise. That's what my learned friend saying. The expert evidence saying otherwise. He says that those condition caused by the delay, how can you say that, how can you maintain your standard saying your client is acting within a reasonable specialist would do?
Thank you for pointing that out, my lady. In assisting the court's concern, we refer to the Code of Professional Conduct 2019 of Malaysia Medical Council, whereby it is stated that the medical consultant can refer to the other appropriate specialist when it is deemed necessary. In the present case, our client did not make the referral at the material time because it is not necessary, as he had acted based on the available medical evidence, as he had diagnosed the appellant as having secondary progressive multiple sclerosis, made appointments with her and consultation with her. Also, my lord and my ladies, when the first medical treatment with our client, she asked about the numbness, whereby the numbness can still be treated at that particular time according to the statement by the neurologist. As hence, our client did not breach his duty as an independent medical consultant. Am I addressing the court's concern?
Please proceed.
Much obliged, my lord, my ladies. Having finished with the first submission, I shall now move to the next submission concerning on the remoteness of the appellant's damage. On the second ground of the first issue, we will submit that the appellant's damage was too remote and is not recoverable in negligence. There is one sub-argument that will be submitted, which is the damage suffered by the appellant is not reasonably foreseeable to the respondent. My lord and my ladies, reasonable foresight test is on whether a reasonable man in the defendant's position would foresee the damage and the type of damage that has occurred to the plaintiff. My lord and my lady, may I be given an extension of time?
How long do you need?
2 minutes. My lady, much obliged. Furthermore, in the 3 means, fight and another, the defendants were held not liable as they could not foresee that the plaintiff might be exposed to the Wales disease, which is a rare disease in their country. Hence, the damage suffered by the plaintiff was unforeseeable and to be recoverable. In addition, my lord and my lady, the High Court in Zulhasnimar binti Hassan Basri and others, and Dr. Kupu Velumani P and others relied on the evidence that confirmed the condition of the plaintiff placenta, which called the placenta percreta, was a rare condition, and it cannot be detected even with advanced imaging techniques. Thus, it was impossible for the defendants to foresee the implication. My lord and my ladies, in the case at hand, it is impossible for our client to foresee and further give advice about the risk and damage of multiple sclerosis that will be suffered by the appellant, as the bladder cancer and brain damage are not laid down as the common symptoms of multiple sclerosis. Moreover, my lord and my ladies, the World Health Organization reported that Asian descents are at lowest risk of developing multiple sclerosis, with approximately 31,500 people have been diagnosed with multiple sclerosis. Multiple sclerosis is considered as uncommon disease among Asians, as I may refer the court extension to the answers for clarification on paragraph 5, number 4. Besides, the diagnosis and treatment of multiple sclerosis usually conducted by a skilled neurologist. Thus, it is impossible for an independent medical consultant like our client to have the same level of skills and knowledge equivalent to a neurologist and to foresee the further risk and damage of multiple sclerosis. My lord and my ladies,
if I
hence
may
the
ask,
appellant's damage.
Council, if I may ask one
Yes,
last
my
quick,
lord.
if I may ask one last quick question. You mentioned about the remoteness of the damage, but though it is so remote, still, according to the World Health Organization that you have submitted, that there is still chance for Asian descents to suffer from this cancer or this disease. So why didn't your client check on every single possibilities, though this possibility is so remote? Then why didn't your client check all available possibilities so that, you know, diagnosis can be done as a whole, not just, you know, to the uh, 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 point of numbness
Specific.
that, yeah, please.
Yes, my lady.
No, I'm just assisting him.
Oh, okay. Much obliged, my lord and my ladies, for addressing the concern. My lord and my lady, in addressing the court's concern, our client did not foresee as the damage will be suffered by the applicant, which are the blood and brain damage, as it is the not uncommon. It is uncommon symptoms of multiple sclerosis, as when appellant first sought medical treatment with our client, she asked about the numbness and had been diagnosed with secondary progressive multiple sclerosis. Therefore, our client just foresaw the symptoms of secondary progressive multiple sclerosis, which are not the bladder cancer and brain damage that let down the common symptoms of secondary progressive multiple sclerosis. Am I addressing the court's concern?
Thank you.
Therefore, my lord and my lady, based on the foregoing reasons, the respondents respectfully request this honorable to judge and declare that the trial judge was right in law in finding the respondents not liable of medical negligence, since there was no sufficient causation between the failure to advise and the damage suffered by the appellant, which was proven through factual causation and legal causation. As such, the respondents' conduct was not in fact caused the damage suffered by the appellant, and the appellant's damage was too remote and is not recoverable. My lords and my ladies, is there any clarification needed by the bench before my learned co-counsel continues submitting the next issue?
Just last clarification. So you're saying that your client did not foresee anything at all after his first diagnosis?
Thank you for addressing the concern, my lady. As our client had diagnosed the appellant as having secondary progressive multiple sclerosis, thus our client just foresaw the symptoms of secondary progressive multiple sclerosis, which the brain damage and the bladder cancer are not the common symptoms of progressive multiple sclerosis.
Which he did not believe that symptoms will lead to the brain damage.
Indeed, my lady.
Thank you.
It is not common. Much obliged. My learned co-counsel will continue to submit on the remaining issues. May it please this honorable court.
May I begin, my lord and my ladies?
Yes, please proceed.
Nice job, bless. Good morning. May it please this honorable court, my name is Nurfati Nadia, and I will continue submitting the next issue. I propose to take 18 minutes this honorable court to address this issue. My lord and my ladies, with regards to the second issue, we submit that the delay of action made by the appellant amounting to contributory negligence, thus maxim recip sola kita applies. My lord and my ladies, in order to show that the delay of action made by the appellant amounting to contributory negligence and thus maxim recip sola kita applies, there are two grounds to be submitted, whereby the first ground the appellant has fulfilled the elements of contributory negligence as her delay of action has contributed to the damage that she suffered. And for the second ground, as maxim res ipsa loquitur applies, the burden has shifted to the respondent, improving no negligence on his part. My lord and my ladies, may I begin my submission proper? Much obliged. For the first ground that we submit, whereby the appellant has fulfilled the elements of contributory negligence as her delay of action contributed to the damage that she suffered, she has fulfilled two elements under this first ground, whereby the first element, the appellant has failed to take reasonable care of herself by behaving unreasonably in avoiding damage. For the definition of contributory negligence, we submit that in the case of Taranjit Singh, son of Bhagwan Singh, and another, and Dr. Premita Damodaran and another, the High Court in this case stated that contributory negligence means that the plaintiff has failed to use reasonable care for his own safety. Moreover, we also refer to the Section 12, Subsection 1 of the Civil Law Act 1956, whereby it stated that when the plaintiff has failed to use reasonable care of his own safety, it is partly resulted to his own damage. My lord and my ladies, in proving that the appellant has failed to take reasonable care of herself by behaving unreasonably, we refer to the decision of High Court in Hassan bin Datola's case, whereby the court in this case held that the appellant's paralysis was not caused by the operation conducted by the doctor, but was a complication of his injury as resulted before his delay because of the delay in seeking treatment. We also refer to the decision of the High Court in Ahmad Takif bin Amza, Ahmad Huzairi and Kuala Terengganu Specialist Hospital Sdn Bhd and others, whereby the court in this case held the delay on the part of the plaintiff's parent to bring plaintiff to the hospital was unreasonable and had contributed to the increasing of the injury that suffered by the plaintiff. Therefore, my lord and my ladies, to relate to the case at hand, we submit that the delay by the appellant in seeking medical treatment earlier, my lord can refer to the paragraph 1 note problem, whereby it stated that the appellant only sought medical treatment when the symptom first manifested itself 9 months before she made appointment with our client. And also, if I may bring this court attention in the problem paragraph 3, whereby it stated that the appellant also did not attend any medical treatment after 5 months consulting with our client, even after she has been diagnosed with secondary progressive multiple sclerosis. Therefore, my lord and my ladies, this indicates her failure to take reasonable care of herself. Furthermore,
Counsel, if I may stop you there, the delay for in seeking medical treatment after 9 months that the patient has been suffering. So if that is the case, then your client would have diagnosed her with, the bladder cancer or something, but yet your client only diagnosed her with just a secondary progressive MS. So is it not that 9 months of suffering before she went to see your client for any treatment does not even contributed to the negligence on her part?
Thank you for pointing that out, my lord. In existing this concern, when the client first sought medical treatment, when the plaintiff first sought medical treatment with our client, she only asked about the numbness, whereby the numbness is not the common symptom of the multiple sclerosis. Therefore, our client only, based on the statement by the neurologist, the numbness at the mature time can be treated by medicine such as steroid, niacin, and Elaril. Therefore, our client has done his duty of care in serving medical treatment to the appellant by provides all the medicines to help her to reduce the numbness. Therefore, there is no need for our client to refer her to another specialist because of the numbness can be treated at the material time.
Is it not that suppose your client asks the patient how long that she has been suffering from numbness, and upon being told that she already been suffering from numbness for 9 months now, then your client should have done more than just giving her Panadols or something.
Thank you for pointing that out, my lord. May I be given a moment?
Yes, yes, please.
Much obliged. In existing this court's consent, by refer to the mode clarification, paragraph 3, number 4, our client has act based on the had his duty based on available medical evidence. Therefore, he only foresee based on the available medical evidence what the treatment that can he done to the appellant.
But perhaps that your client has never checked on all available possibilities, because according to your Leonard Senior Counsel, that Asian descent might also suffer from this kind of cancer. So the numbness is the beginning of this suffering. So your client did not even check this kind of possibility. Don't you think so?
Thank you for pointing that out, my lord. Indeed, our client has done the diagnosis, whereby he diagnosed the appellant with secondary progressive multiple sclerosis. However, the damage that appellant suffer, which is the brain damage and the bladder cancer, is not the common symptom of the multiple sclerosis. Therefore, our client could not foresee the further damage that the appellant could suffer, because in addition, this disease is not a common disease in the Asian descent. Therefore, it is impossible for our client as an independent medical consultant, not a specialist or neurologist in this field of disease, could foresee the further damage that the appellant could suffer.
But is it not that secondary progressive MS would have developed into a 3rd degree progressive MS or 4th degree of MS, progressive MS? So your client would have known and would have foreseen that it would have developed into another degree, another progression. Yet your client has never referred or take any precautionary measure to inform the patient to go and seek for other consultations with other doctors.
Thank you for pointing that out, my lord. In existing this court concerns, according to the Code of Professional Conduct 2019 of Malaysian Medical Council, it is not stated in the memory, by the way. The guideline in that code, it provides the guideline for medical consultant to make a referral, and it stated that the consultant only need if there is readiness or necessary circumstances to do so. But however, our client, at the matter of time, our client is not necessary to make a referral, because he has also acted based on the available medical evidence, as he diagnosed the appellant with having secondary progressive multiple sclerosis, and also he had made appointment and consult her. Also, when the appellant first sought medical treatment with our client, she asked about the numbness, and the numbness can still be treated according to the neurologist that I stated just now. Hence, our client did not necessary to make a referral at the material time.
But on the basis of contributory negligence. So it's basically when it comes to contributory negligence, it only contributes to the negligence. It does not negate that your client is also responsible. I mean, like what my learned friend saying just now, it is, it is a negligence if you, as a doctor, did not disclose any material risks or warning your client or your patient regarding to the risks that they will face. How you respond to that?
Thank you for pointing out, my lady. May I be given a moment?
Sure.
I shall oblige. In existing discourse concern, we refer, it is indeed in the contributory medical negligence, the part, they are partly part of the defendant negligence, also partly part of the appellant negligence. But according to the case Jones and Levox Quarries Limited, same and same, the judge in this case stated that when one is considering the question of contributory negligence, it is not necessary to show that the negligence constituted a breach of duty to the defendant. It is only sufficient to show lack of reasonable care by the plaintiff for his own safety. Therefore, to relate in this current situation, it is not necessary to say that our client negligent. It's only necessary under this contributory negligence principle to show that the appellant has failed to exercise reasonable care in order to avoid any deterioration of her health condition, right?
Does failure to exercise reasonable care means a breach to duty of care?
Thank you for pointing that out, my lady. In existing discourse concern, our answer is no.
Counsel, I have a question. In your memorial, you've argued that because there is contributory negligence, then the maxim res ipsa loquitur applies. Okay. So what is your basis for this? Because res ipsa loquitur, shifting the burden, is something else. Contributory negligence is a different issue altogether. So I don't actually see the correlation between these two arguments.
Thank you for pointing that out, my lady. In existing discourse concern, by referring to the statement by the judge in the Mahan and Osborne case, res ipsa loquitur, the elements of res ipsa loquitur is whereby first the defendant was in exclusive control of the situation, and second, the plaintiff must prove the damage is something that will not ordinarily happen if the defendant takes adequate precaution, and the last element is the causes of the accident is not known. Therefore, to relate to the contributory negligence, this maxim applies because there is no the causes of the accident in this particular case, the appellant said is not known. Therefore, we use the contributory negligence because to rebut that the appellant also contribute the negligence.
Okay, counsel. I'm sorry, I have to stop you there. I don't think that's entirely correct, because we do know in this case what the causes are. It was the delay of referral and all that. So this res ipsa loquitur, I would think it applies in cases, for example, our recent the LRT accident where consumers don't have any control with what happens. It's not something that I would think applies to medical negligence cases. So what is your response to this?
Thank you for pointing that out, my lady. In existing discourse concern, we indeed submit that this maxim, once it applies, it shifted the burden to our client to prove no negligence on his part. That's why. Am I addressing this court's concern?
No, I'm saying that I don't think it applies in this case. That is my concern, actually, counsel.
Thank you for pointing that out, my lady. It indeed stated in the paragraph 10b that the maxim is applies in this case.
Counsel, if I may, now the fact says that after 5 months of the treatment received by the patient, then the patient no longer seek for medical treatment, and thereafter she went to Kota Kinabalu to follow her husband. So my question is, if she still attend and see your client for medical treatment and did not go to Kota Kinabalu, would the treatment be still the same, or your client would have used different treatment, or refer her to other specialists?
Thank you for pointing that out, my lord. The answer is yes, because if there is no delay on the part of the appellant, our client could know the progress of the symptom that she suffered. Therefore, our client can know the further action need to be taken to her if he did not delay, if she did not delay in seeking medical treatment. Because when she moved to Sandakan, there is difficult for our client to know progress of her symptom and further make a referral for her.
But according to your submission, that numbness can be treated just by giving medication. So if the patient still go and seek for your client's advice and treatment, then your client would have been given her the same treatment.
Yes, my lord.
Proceed.
Much obliged. Furthermore, applicant also have failed to take reasonable care of herself by behaving unreasonably when she was continuously delaying her treatment, as stated in the paragraph 4 problem. Firstly, whereby the appellant has failed to take reasonable care of herself when she stopped seeing our client in January 2019, where she moved to Sandakan for her husband's food transfer. And secondly, when about a year after consulting with our client, and only then she sought another medical treatment with another doctor, which is Dr. Hans. Hence, my lord and my ladies, this prevents that the failure of the appellant to take reasonable care of herself by behaving unreasonably in delaying seeking medical treatment has contributed to the deterioration of her health condition, and this proven she has failed to take reasonable care of herself as person would when suffering multiple sclerosis. Is there any clarification needed by the bench before I proceed to the next element? Much obliged. For the second element under this first ground that have been fulfilled by the appellant is, appellant's damage is reasonably foreseeable from her act or omission. For the definition under this element, we refer to the statement from the High Court in Taranjit Singh case, whereby the court stated that contributory negligence is depending on whether the claimant ought to have reasonably foresee to the harm himself if he failed to take reasonable care of himself. My lord and my ladies, improving the appellant's damage is reasonably foreseeable from her act or omission. We refer to the case Kwek Ho Bok and Lee Sing Kweng. The case is distinguished facts with our case at hand, that the principle in this case is similar, whereby in this case the plaintiff has contributed towards his own discomfiture, as he ought to reasonably foresee that if he was not drive at a safer distance and speed behind the taxi, the collision between them would happen when the taxi was stopped. And also, we refer to the case Jones and Levox Quarries Limited. Once again, this case is distinguished facts with our case at hand, but the principle is similar in our case. The Court of Appeal in this case held that the plaintiff did contribute to his injury when he claims and rode upon the backs of the excavator, even though he knew and reasonably foresaw that such conduct was dangerous. Therefore, my lord and my ladies, to relate to the case at hand, the appellant has contributed towards the deterioration of her condition as she ought to reasonably foresee the damage that she could suffer when she failed to take reasonable care of herself in delaying her medical treatment from the beginning, whereby from the first symptom manifest itself 9 months before she consult with our client, and she also continuously delaying her medical treatment after 5 months consulting with our client, and also she did not attend about a year after she consult with our client, she did not attend any medical treatment, and then about a year after that, she only then she sought another medical treatment with Dr. Hans in Sandakan. Besides,
But counsel, according to the facts, para 4, just after 5 days of this DBS procedure, then Dr. Hunt concluded that she is suffering from a disease more than just numbness. So how could how could your client cannot detect this possibility even after 9 months or even after 5 months that the patient has, came and see your client instead?
thank you for pointing out, my lord. In assisting this court's concern, we refer to the statement by neurologists, whereby state that the symptom of secondary progressive is not constant. Therefore, at the mature time, our client only detect the symptom of numbness at the mature time, and it also a year before she consult with Dr. Hans. Therefore, after a year that she consult with us, with our client, then the symptom manifests itself at the mature time, because the symptom itself is not constant as was stated by the neurologist. Am I addressing this court's concern? Much obliged. Besides, improving the appellant's damage is reasonably foreseeable from her act or omission by considering her age and gender, which is a 45 years old lady. She is more vulnerably exposed to the disease. Therefore, she ought to reasonably foresaw that if she failed to behave as a reasonable person when having multiple sclerosis, wish to seek for medical treatment earlier, she could suffer damage. As was stated in the paragraph 4 problem, which stated that considering the age and gender of the appellant, she is more vulnerably exposed to the disease. And also, to support this statement, we refer to the statement by neurologists who are expert in multiple sclerosis. In the book of Understanding Progression in Multiple Sclerosis, it stated that the average age of onset in multiple sclerosis when people are in their 40s and 50s. Therefore, by looking at the age of appellant, who is 45 years old lady, we submit that she is indeed under the category of risk people to suffer multiple sclerosis. Thus,
So,
Counsel, on that part, yes, interesting. In your statement just now, your submission just now, I just have one question: whether your client has knowledge that the patient is 45 years old and is within the risk group patient. It's yes or no answer.
thank you for pointing that out, my lord. Before that, may I be given an extension time?
I think, yeah, just answer my question. It's yes or no, and then just proceed with your submission.
Yes, answer yes.
Thank you.
Okay, counsel, I have another question. Based on what you submitted, you seem to place a high burden on patients and then say that, they've contributed to this. I mean, if you ask me as a layperson, I also don't know what multiple sclerosis is. So, it's very I think dangerous for you to argue that your client should have foreseen what the consequences are for not taking care of herself, because the fact is she wouldn't know. And what more if we have a 70-year-old lady or 80-year-old lady? So I think you have to be a bit careful with what you're arguing here, counsel.
Thank you for pointing it out, my lady. We before the appellant have consult with our client, she has felt the symptom of numbness with a long term, which is 9 months. So therefore, it is reasonable for the layman to seek medical treatment at the particular time, because the long-term numbness is not a common layman could feel, because because a numbness usually the short term, which is it can disappear after disappear in days, in days, but appellant felt the numbness for 9 months, 9 months long. Therefore, she could seek medical treatment early.
Yeah, so that's exactly my point, counsel. Because she knows that something's not right, she's seeking treatment, and she is then relying on the advice of the doctor. What do I do next? So that is, I think, what the concerns of my fellow judges and I are in this case, counsel.
My apology, my lady. Can my lady repeat back the question?
Okay.
It's not
So,
quite
okay, so
clear.
basically, I think your argument is that the patient, there are a lot of contributory negligence on her part that has contributed to what she has suffered. So my point is, she knew that something was not right, which is why she sought treatment in the first place. So now, having seen a doctor, she, as a layperson, relies entirely on this doctor to give advice and treatment and tell her what to do. Because as a layperson, she wouldn't know what to do. So having relied on this doctor, I don't think it's fair for your client to argue that she should have known better, or she should have foreseen certain things. So I think that is my only concern.
Thank you for pointing that out, my lady. In resisting this court's concern, our client indeed have done the diagnosis, the treatment, the consultation based on the available medical evidence as stated in the paragraph 3 mode clarification number 4. Therefore, it is the burden on the appellant to take reasonable care of herself after she has been diagnosed with the secondary progressive multiple sclerosis, and also consider to her age. She is not a young lady with have a better health condition, so she could take reasonable care, to more concern about her health condition. Am I addressing this court's concern?
Thank you, counsel.
Much obliged.
Time is up.
May I be given an extension of time?
Just conclude, counsel.
Much obliged. Therefore, to conclude my submission, the respondent submit that the appellant has contributed to the deterioration of her condition due to the delay of action made by her, and hence maximum reciprocity allocated applies, and so burden has shifted to the respondent himself, refuting the presumption of negligence made by the appellant. Therefore, my ladies and my lord, based on the foregoing reasons, the respondent respectfully requests this honorable court to adjudge and declare that the trial judge was right in law in finding the respondent not liable of medical negligence, and the delay of action made by the appellant amounting to contributory negligence. Therefore, maximum res ipsa loquitur applies. If I am of no further assistance to this court, that shall conclude my submission. Thank you for your time and indulgence.
Thank you, counsel.
Much.
Young Arif and my ladies, may I proceed with my rebuttal? Much obliged. Young Arif and my ladies, the appellant today has 4 quick points to be made. First, at page 4, paragraph 18 of Respondent's Memorial, they submit that in Tremens and Pike and another, the defendant were held not liable as they could not foresee that the plaintiff might be exposed to the whale's disease, which is a rare disease. Hence, the damage suffered by the plaintiff was unforeseeable. I would like to rebut this point by citing the case of Rogers and Whitaker, where the High Court held that the doctor should foresee the risk of sympathetic ophthalmia, which occur after penetrating surgery to the other eye, even though this is a rare condition. Second, by referring to page 5, paragraph 22 of Respondents' Memorial, they submit that the diagnosis and treatment of multiple sclerosis usually conducted by a skilled neurologist, and it is impossible for an independent medical consultant like Dr. Kevin to have the same level of skills and knowledge equivalent to a neurologist. Hence, I would like to refer this court to the Code of Professional Conduct 2018 from Malaysian Medical Council under the first heading of Part 2 concerning neglect or disregard of professional misconduct, paragraph E of responsibility of standards of medical care to patient. It states that the public is entitled to expect that a registered medical practitioner will provide and maintain good standard of medical practice, which includes to refer the patient to another professional practitioner when the circumstances are so warrant to consult. Hence, in applying to this instance case, Dr. Kevin should refer Amrita to a specialist specialized in multiple sclerosis, which is a neurologist, as our learned counsels themselves submit that Dr. Kevin do not have the same skills and knowledge equivalent to a neurologist. Third, our learned counsel submitted in their memorial page 8, paragraph 34, which Amrita need to foresee the damage. And our learned counsels also submitted orally regarding the reasonable foresight test. I want to draw this court attention to Dr. Kevin, which is a recognized medical practitioner, to compare to Amrita, who is an old lady with no any medical background. Thus, Dr. Kevin, in his capacity, cannot escape from his responsibility only by giving excuse that the disease is rare and do not have any obvious symptoms. Lastly, I would like to uphold the importance of control tests, which the respondent did not mention. In the case of Dr. Koh Chung Seng and another, and Su Cheng Lin and another appeal, paragraph 85, stated the element of control is no longer regarded as the sole or determinative criterion. However, it remains an important factor. As held by this court in Ho Kiang Ngan and Mahkamah Perusahaan Malaysia and another, all cases where it becomes necessary to determine whether a contract is one of a service or for services, the degree of control which an employer exercises over a claimant is an important factor, although it may not be the sole criterion. Besides, Section 15, Subsection 3, Paragraph B of Occupational Safety and Health Act 1994 states that the duties of an employer extend to such an independent contractor, and the employer must be a person who has a control over the independent contractor. With that, I rest my case. Much obliged, and may it please this Honourable Court.
So can we just seek clarification? Can you hear me, counsel?
Yes, my lady.
Okay, yes. Sorry, they've also raised contributory negligence, the respondents. So can you give a short reply to that? As part of the main submissions, the respondent has said that there is pretty much contributory negligence on part of your client, and you've not addressed that in your rebuttal.
My apology, my lady. May you replace your question?
Okay, the respondents have argued that there is contributory negligence on part of your client. You've not addressed that point in your rebuttal, So is it possible for you to just do a short rebuttal on that point?
Thank you, my lady, for pointing that out. In responding to contributory negligence, I would like to rebut this point by drawing this court attention to Dr. Kevin, which is according to the mood problem, page 1. Mm, my apology. Paragraph 2, which is stated that Dr. Kevin is independent medical consultant, which it clearly gave us the meaning that Dr. Kevin is a registered medical practitioner, which we cannot compare Dr. Kevin as a registered medical practitioner to a layman, which is Mrs. Amrita, which is an old lady and does not have any medical background. That is why Mrs. Amrita, the appellant, cannot be regarded as contributing to the negligence.
Thank you, counsel.
May I begin my rebuttal, my lord and my ladies?
Yes.
Much obliged. My lord and my ladies, there are 3 quick points that the respondents would like to rebut based on the appellant's rebuttals. Firstly, the appellants contended the respondent is responsible to fulfill his duty to diagnose, to advise the appellant regarding her disease and treatment accordingly, which failure amounting to negligence. Nonetheless, we argue that our client has fulfilled his duty as a medical consultant as he had acted based on available medical evidence as he had diagnosed the appellant as having secondary progressive multiple sclerosis, made the medical appointments and consultation with her according to the guidelines provided under the Code of the Professional Conduct 2019 provided by Malaysian Medical Council. Also, when the appellant first sought medical treatment with our client, she asked about the numbness which can still be treated at that particular time. Hence, we submit that our client had fulfilled his duty as an independent medical consultant. Secondly, the appellant has submitted that if the respondent referred the appellant to any other specialist, she would not have had her secondary progressive multiple sclerosis, thereby argue that even our client advised her on his referral, according to expert evidence, with no delay in referral, the appellant would have 40%. Hence, on the my lord and my ladies, the balance of property is not negligent, as the probability resulted in the desired outcome less than 50%, and the appellant has failed to prove. We submit that our client's action was not a but for reason, as the damage would have happened anyway, as stated in the case of Dr. K.S. Sivanathan and the government of Malaysia. Thirdly, the appellant has contended that our client has failed to advise the appellant on the risk of bladder cancer and brain damage. Nonetheless, we respondents argue that it is impossible for our client to foresee and further give advice about the risk and damage of multiple sclerosis that will be suffered by the appellant, as the bladder cancer and brain damage are not laid down as the common symptoms of multiple sclerosis. In addition, my lord and my ladies, multiple sclerosis is considered as uncommon disease among Asians as stated in the mood problem paragraph 4 and further clarified in the clarification mood problem paragraph 4. and hence we submit that the diagnosis and treatment of multiple sclerosis are usually conducted by a skilled neurologist. Thus, we submit that it is impossible for an independent medical consultant like our client to have the same level of skill and knowledge equivalent to a neurologist and to foresee and advise the further risk and damage of multiple sclerosis. As our client had fulfilled his duty of care and did not breach the duty. Also, there is no sufficient causation between the failure to advise or in referral and the damage suffered by the appellant. Hence, there is no need for us, there is no vicarious liability upon the NILAC SMX Nilai Medical Center. Based on the foregoing reasons, the respondents respectfully request this honorable court to adjudge, declare that the trial judge was right in law in finding the respondents not liable of medical negligence, and secondly, the delay of action made by the appellant amounting contributory negligence, therefore, maxim res ipsa loquitur applies. This sums up the respondent's case. Much obliged, and may it please this honorable court.
Thank you.
Much obliged.
Okay, thank you to all the applicant and respondent. So the Honorable Court is now adjourned. Participants are to exit this breakout room and enter the main room to allow the judge to fill up the score sheets in this room. So please do not exit the window or click leave meeting. You will be invited back into this room, into this moot room once the judge has finished the scoring.